Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business. Very glad to share his time with my friend Lee Kaplan, who's extraordinary at what he does. He's an incredible attorney, a brilliant mind, and a regular contributor on the program. I always look forward to it because I know I'm going to have a robust discussion on what's happening with the law, and particularly as it relates to business and politics. And I'm sure today it's not going to be any exception to that. His law firm, by the way, you can learn more about his firm at skv.com. That stands for Spicer, Kaplan, and Veselka. And Lee Kaplan, how are you, sir?
Good morning. I'm great. How are you, Kevin?
Good, thank you. And tell us real quickly about your practice before we get into our topics today. And we're going to go a little longer because you're Lee Kaplan. Tell us a little bit about your firm, and then we'll get into our topic.
Well, our firm is a litigation firm, which means trials, arbitrations, appeals. Our most recent trials include a trade secrets trial in federal court in which I was involved, and commercial arbitration in which two of my partners were involved. We tend to represent businesses ranging from small proprietorships to Fortune 10 companies, and we're in all the courts, federal and state courts in Texas, but also in other states as well. Mm-hmm. So we try to advise businesses about the risks of litigation, and we go to trial whenever it makes sense.
Absolutely. And let's talk about the topics. I thought that you brought a couple that were very interesting. The Obamacare one being the one that I think particularly those in business are kind of sitting with anxiety, wondering how that's going to unfold.
Well, I think it's fairly interesting that one side has promoted a doomsday scenario if the law is struck down. I don't believe that, just as I didn't believe the doomsday scenario if the law were passed. I personally believe, just myself, that when I hear somebody say, well, there are just four little words in the statute, that shouldn't control everything. Well, my gosh, the word not would be one little word, but words mean something, and the statute does not supply authorization for a federal exchange. So personally, I think the Supreme Court is going to strike down the law.
Okay. Now, what's interesting, though, isn't it true, Lee, that there's normally in legislation a provision at the end of every legislation that says that whatever doesn't hold up will still remain intact, if any part of this provision fails. But that didn't end up being in this particular law, making the whole thing vulnerable.
I'm assuming that the rest of the law would survive. The argument is that the whole edifice is not sustainable unless you have all these other participants who are paying premiums involved. If you don't have the federal exchange, then you have a lot of people losing their coverage, and you have a lot of insurers who are not getting the benefits of more people to spread various risks around, et cetera. And I think this actually poses political problems for both sides. It poses problems for the Democrats who rushed a law into existence which was very sloppily drafted, and it proves Nancy Pelosi's comment, we've got to read the law to know what it means. But it poses a lot of risk for Republicans that people who have gotten these subsidies through the federal exchange are going to lose them, and they may blame the Republicans. So
yeah.
The Republicans are talking about stopgap measures if the law is overturned, or at least this portion of it. I personally believe that if the judges are not thinking politics but they're thinking law, that that's what's going to happen. But I guess we'll find out soon.
So you're thinking that the Republicans may have put themselves in a more dire situation pushing this. Of course, it wasn't the Republicans who were actually pushing this per se. It was I think in this case pro-family groups, social conservatives that were pushing this.
Actually, I have read a story that some lawyer in maybe North or South Carolina happened to notice this as they were looking at the statute overall, and for quite a while people were pretty skeptical about this kind of challenge, and then ultimately they probably moved to this after the law was upheld generally by the U.S. Supreme Court the last time around. Don't know that, but that's what I have heard. So, but with 300 million Americans, you never know where and how a lawsuit is going to come about that makes it to the United States Supreme Court. So,
yeah, that's exactly right. Now, the Supremes have passed down decisions in certain areas. What do you think is making them wait on this one?
Well,
because this week they've already been, the last 2 weeks they've already been, releasing this here and releasing that there, but we haven't heard anything about the Obamacare case.
Well, I think the natural order of things is that people try to polish opinions. When you're at the Supreme Court, you have law clerks. People want to pore over the opinions and try to avoid making a foolish mistake. And that's not surprising. They wouldn't release all their opinions on one day. They get out some important or controversial opinions, and then they wait a while. And you also generally wait on the dissenters as well. You don't release an opinion until the dissent has written its dissent. And in general, from what I can tell, people who are dissenting on the Supreme Court are fairly conscientious about writing their dissents carefully and not holding up an opinion on the basis, or a decision, holding up a decision on the basis of, well, I haven't finished my dissent yet. So I don't think there's that kind of gamesmanship going on up there. I don't have any personal basis to suspect that happens.
Okay.
So I think they're just doing it in deliberate fashion, and they'll get it done when they get it done.
Okay, very good, very good. There's another big case, obviously, that you're talking about, that being gay marriage. What do you think is going to happen there?
I have a feeling that the Supreme Court is going to find a way to say that states cannot ban it. And I think that there will be some people at very high decibel dissents. And, this is just the way our society seems to have moved in 5 years. And I think that they're going to follow that. And frankly, this may sound a little bit conspiratorial, but the Supreme Court tries to keep itself aware of what's happening in the rest of the world. If they're going to strike down Obamacare, I don't think that they'll uphold a ban on gay marriage at the same time. That may sound cynical, but the Supreme Court has to be relevant, and it's taken a lot of beatings from commentators, and in our highly polarized political environment, there's a little bit of evening up the calls, I think.
Really? That's fascinating. And it is a little cynical, but, I'm cynical all the time. So,
Well, it's not the first time that ever happened.
Yeah.
Back in the New Deal, there was the famous switch in time that saved 9, that when the Supreme Court was striking down all this New Deal legislation, and Roosevelt was proposing to pack the court, in a way, saved itself by the fact that Owen Roberts switched his vote, and suddenly New Deal legislation started being upheld as either the commerce power or other bases, and that helped doom the court packing plan. So,
of course, cynical.
Wants to. I'm sorry. Go ahead.
I was going to say, cynical minds like mine said, yeah. Well, in other words, the Supremes became a rubber stamp for the executive branch, kind of negating checks and balances.
Well, I wouldn't say negating it. I would say trying to hold on to the influence that they had. After all, we do have a law-abiding tradition, and I realize that many people say the law is whatever the Supreme Court says it is, and that changes all the time. There is something to that. There's a tension between changing with the times and trying to stay true to what the founders meant. But I don't think any member of the Supreme Court can be accused of not being aware of the wider world and its role within our community and how things work. So I personally think they're going to strike down the federal exchanges in Obamacare, but I think they're going to also say that gay marriage bans are unconstitutional.
Yep,
we'll find out pretty soon whether I've gotten too far out on either limb.
Yeah. Well, I think you're probably, based on what I've been seeing recently, you're probably correct on that, on both. Although I will say, the general belief is that the Supremes never want to be ahead of society. They want to be where the consensus of society is comfortable when it comes to a decision. And some of the questions asked by some of the justices that, like Kennedy, for example, that I thought would be one that would be more comfortable with that, makes me wonder if they think society is that far ahead yet.
Well, you can fake left, go right, and vice versa. I think some justices, you can tell what they're thinking from their questions. Others, and Kennedy would probably be one of them, are people who ask probing questions, maybe of both sides, maybe of one side, and that is not a real marker for what they're thinking.
Okay.
Speaking of being somewhat political, I thought the Texas Supreme Court's recent ruling on gay divorce was pretty interesting, too.
Yeah, talk a little bit about that real quick with a couple minutes left.
They found an out. I mean, basically, a couple was divorced quite a while ago, and the Attorney General for Texas, Greg Abbott at the time, intervened, and the court has said you intervened too late. So this divorce is being upheld. I don't think they really ruled that gay divorce is allowed. They just said basically it's too late. Your appeal is rejected. And in a way, this gives them the opportunity to wait on the U.S. Supreme Court and see what it has to say about gay marriage. I don't think that the members of the Texas Supreme Court really want to get too far out in front on this and then find themselves smacked by the U.S. Supreme Court. So I thought that was kind of interesting.
I think so, too.
I know Governor Abbott was really put out about that, but frankly, I think that was the right ruling on the merits, not the merits of gay marriage or divorce, but just on the merits. They intervened too late.
Too little, too late, I guess, as that saying goes. All right, Lee Kaplan is his name. He's a regular here on The Price of Business. He's with the firm of Smizer, Kaplan, and Veselka, and that's skv.com. As always, thanks for your time.
Okay, one last thing to think about we can talk about next week is the Texas Supreme Court ruling on the extent to which an injured worker can sue his or her employer when the employer is a non-subscriber to the workers' comp statute. We'll talk about that the next week.
That's interesting. Because that would really shake things up in a state that boasts not having workers' comp being required. That would really shake
sort of. On the one hand, the court giveth; on the other hand, it taketh. It's kind of a interesting mixed ruling.
Well, and I'll also look forward to getting your assessment on what actually did happen. So that'll be, with the Supremes, U.S. Supreme. So Thank you, sir. When we come back, much more for you. Do want to remind you, best content here shows up over there at usdailyreview.com. While they're like it on Facebook, follow it on Twitter.